I have represented people who have been on the, offensive side. I've had clients who we send cease and desist letters, we file petitions to cancel other people's trademarks with the Trademark Trial and Appeal Board. And then I've also I've represented people on the other side, people who are on the defensive and they've received a cease and desist letter, or they've been served with some kind of notice that someone's going to try and cancel their trademark. But one thing I like about trademark law is of this area of law, I would say it's very predictable. It just seems to be where if the facts and the law is on your side, it tends to go your way. I don't want to say it's easy to advise people, but it just seems that it's easy to sort of steer the ship and help people kind of know where things are going based on the facts and the law. So that helps, because in other areas of law it can be, things can be very wishy-washy, where it's really, things can be very subjective. And of course, whether or not something's confusingly similar, there's a lot of subjectivity to that. But one thing that is very black and white is who used something first. So if somebody started using something first and they can prove it, and the marks are identical, that's really not very complicated, and you'll have the two lawyers on each side. They're both going to understand how that's going to play out. So it ends up being, more, the negotiation can vary how things go, but I feel like you can be pretty confident that what's going to happen, and you can advise the client that it's going to go a certain way.